Good morning.
Good morning, Judge.
Judge, how are you?
Good. Chambers County Probate Court come to order. If you are going to testify today, I need you to raise your right hand, please.
Yeah.
Do you solemnly swear or affirm the testimony you're giving today is true and correct, so help you God?
I do.
I do.
Okay, you can put your hand down. First on the docket, cause number 130, the state of Richard Zavala. Mr. Mayo, good morning.
Yes, sir. Good morning, Judge.
And you may
I
proceed.
All right. I have two witnesses for us today. I have Miss Eileen Lewis appearing on Zoom, and I saw her a moment ago. There
Yes,
she
I'm
is.
here. Yes.
All right. Okay. So we'll go ahead and begin. Miss Eileen, you are a notary public in the state of Texas, correct?
Correct.
Okay. And on July 18th of 2023, were you present and saw Mr. Richard Zavala sign the document that I sent you a copy of this morning that purports to be his last will and testament?
Correct.
Okay. And at the time this document was signed, he was at least 18 years of age, correct?
Correct.
All right. He published and declared that document to Ms. Natalie Iglesias, Olivia Meese, and you to be his last will and testament, correct?
Correct.
And he wanted Miss Natalie and Olivia to witness it and you to serve as notary, correct?
Correct.
All right. Natalie Iglesias and Olivia Meese were both over the age of 14 years of age at that time that they signed that document, correct?
Correct.
All right. And you, as a notary, were over the age of 18, and you were known to Natalie and Olivia, correct?
Correct.
All right. To the best of your knowledge, was Richard Zavala of sound mind at the time he signed that will?
Yes.
Okay. And just, we're all human beings. Something happened, and the notary stamp did not make it onto that will, correct?
Correct.
In fact, I have Ms. Varner here. Y'all did a will for her at the same time that was nearly identical, and it had its stamp and everything, correct?
Correct.
All right. With that, Your Honor, I would pass Ms. Lewis to you.
No questions, Counselor. You may continue.
All right. My next witness is sitting here with me, Ms. Levada Varner. Ms. Levada, would you please state your name?
Levada Varner.
And is it true that you are Richard's surviving wife, correct?
Yes.
All right. And Richard passed on December 8th of 2025 in Mont Belvieu, Texas at the age of 79, correct?
Yes.
And that means it's been less than 4 years since he passed, correct?
Yes.
Okay. And Richard was a resident of, had a fixed place of residence in Chambers County, correct?
Yes.
The document that we have a copy of right here for you is dated July 18th of 2023. And that is his last will and testament, correct? Or that's a copy of his last will and testament, correct?
Yes.
A necessity exists for the administration of his estate. There's some real estate and things to take care of, correct?
Yes.
Richard had no children and did not adopt any children after he executed this will, correct?
Yes.
Okay. And he did not divorce after executing this will, right?
Yes.
Richard's will names you as a devotee and the independent executor, correct?
Yes.
All right. And Richard did not receive Medicaid benefits on or after March 5th of 2005, correct?
Yes.
March 1st, excuse me. And you, Ms. Levada, are an executor named in his will. You're not a convicted felon. You are qualified. You are not disqualified from accepting letters, and you are entitled to receive letters, correct?
Yes.
Thank you. At this time, Your Honor, I'll pass Ms. Varner to you.
No questions, Counselor.
All right.
Anything else?
We just ask that you admit the will to probate and appoint Ms. Levada Varner as independent executor without bond. And just want to recognize that she started out with the wonderful Mr. Roy Fuller, and I'm honored to take over his file on this one. So,
Yeah, good guy. Good guy. Eileen, do you have your hand up?
Here.
Oh, go ahead.
Oh,
You
no,
have something?
sorry. I didn't have my hand up.
Okay.
Sorry.
All right. Hereby move the will of probate and authorize letters. Thank you, Counselor.
Thank
You
you.
ladies have a good day.
Thank you. You too.
Thank you, Ms. Lewis.
Thank you.
You're welcome.
All right. Cause number 4, the state of Ronald Latsey.
Ready, Your Honor.
I want to see your pretty face. Ah, there you go. Let's see that hairdo.
It's brand new, fresh buzz.
Uh-huh.
Uh,
Did we swear you witness him?
Judge, we would like to request that this case be moved, whether that means we just need to coordinate with the case to get it reset for a hearing next month,
Okay.
if we can do that.
We'll do it. Christy, make a note of that.
I will reach
Fine.
out to you.
Thank you, Christy. Thank
You're
you, Judge.
welcome.
All right. Thanks, Daniel.
All right, y'all
Have a
take
good day.
care. Y'all too.
All right, call number 13, the state of Stephen Bailey Stelly. Mr.
Yes, sir.
Wimberly?
Present, Your
Oh,
Honor.
there you are. Okay. All right, you may proceed.
Mr. Stelly, you are the son of the deceased Stephen Stelly,
I am.
and you recall in 2022, you and your dad were going on a hunting trip, and I had been on him about getting a will done,
Correct.
and in fact, you're the one who introduced me to your dad to help him do some business deals for him.
That's correct.
I had represented you for several years before that.
That is correct.
And so we put a will together pretty quickly in December of 2022, and you're familiar with that will, correct?
That is correct.
And that's the original, which is before the court, correct?
That's correct.
And as far as you know, you're aware of the fact that that will is the one that your dad had told you about and actually had given you a copy because you were named as executor of the will.
That's correct.
And that will was never revoked by your dad.
Yes, sir.
Okay, and your dad lived in Chambers County for decades, including the property here outside of Winnie area for decades before he executed the will, but clearly from 2022 to the present, correct?
Yes, sir.
Okay, and your dad named you as executor in that will.
That is correct.
And there are two heirs of that will, you and your sister, correct?
That is correct.
And your sister does not object to you being executor of the will because in fact she lives in Wyoming and is not available, correct?
Yep, that is correct.
Okay, and you're not aware of any issue that would prevent you from being qualified to serve as executor of the will.
Yes.
Okay. And you're prepared to do that. And in fact, you have stepped in since your dad passed on and has been taking care of his farm and his farming operations since that happened, and doing the best we can, waiting on the deal. Because in fact, on the various businesses your dad had, you were already named as a manager before his death, so that if something did happen to your dad, you could continue to operate the business.
That is correct.
Okay, and you would ask the court to appoint you as a executor and allow you to be issued letters testimony without a bond, correct?
Correct.
Your Honor, I pass the witness to the court.
No questions, Counselor.
Okay.
Hereby admit the will to probate and authorize letters. I don't have an order. Christie, we're waiting on an order.
Your Honor, if you don't have that, we will get that to you. My office, when the storms came through Friday, we had multiple lightning strikes and it hit my router, my backup router, my computer, and they're promising me it'll be up by tomorrow. But I believe in electronic people is about as much as I can throw them. So when it happens, I promise you we'll have it delivered to you. And
Okay, no problem.
Your office was very kind and explained the situation.
Yes, ma'am.
And as soon as we have it, we'll get it to Judge.
Thank you very much, ma'am. Thank you.
Thank you. Have a good
Thank
day.
you, sir.
All right, cause number 22, the state of Stephanie Lynn Green. Ms. Rendon.
Hello, Your Honor. How are you?
Good morning. I'm good. How are you?
Good, thank you. So we're here to probate the will for Miss Stephanie Lynn Green, decedent died on December 10th, 2025. Decedent's date of death was less than 4 years ago. Decedent was a resident of Chambers County at her time of death. I do have a copy of the will that's been filed of record, and I do recognize that to be the last will and testament of Miss Stephanie Green. To the best of my knowledge, she did not revoke her will. She was not divorced after the date of the will. There were no children born to adopted by decedent after the date of the will. There's no state or government agency or charitable organization named as a devotee. There is a necessity for an administration. Her will appoints her husband, Mr. Darrell Green, as the executor. He is qualified to serve as such and accept letters. The estate is non-taxable and we request the appraisal be waived, Your Honor.
So done. Thank you, Counselor. And we need an order on this one also.
Oh, we do? I'll get that filed today. My apologies.
I don't see one.
I feel like there is one, so
Okay.
Lacey, let me look again.
Okay, I
Sorry
appreciate
about
it.
that.
Just email me and
That's
let me know.
All right. Thank you, ma'am. Have a good
Thank
day.
you. Have a good day.
Cause number 23, the state of Linda K. Gonzalez.
That is me, Your Honor.
You may proceed.
All right. My name is Colton Wade Mayo, and my personal knowledge that Linda K. Gonzalez passed on December 15th, 2025 in Baytown, Harris County, Texas at the age of 83. So 4 years have not elapsed since the date of her death. She was a resident of, had a domicile and fixed place of residence in Chambers County, Texas. I have a copy of the document that was dated July 16th, 2025, and that purports to be her last will and testament. To my knowledge, it was never revoked. A necessity exists for administration of this estate. No children were born to or adopted by her after the execution of this will. No marriage of hers was ever dissolved. The will does not name the state of Texas, an agency of the state, or a charitable organization as a devotee. And Mr. Julian Perez Gonzalez Jr. is named in the will as an executor. He's not a convicted felon. He is qualified and not disqualified from accepting letters testamentary, and he's entitled to receive those letters testamentary. So we ask that you appoint Mr. Julian Perez Gonzalez Jr. as independent executor without bond.
So done. Thank you, Counselor.
Thank you.
All right. Cause number 27, the state of Ron Wayne Sandlin.
I'm afraid this is the 10 a.m. docket sponsored by Mayo and Poland, sir. So
Apparently.
So I just want to make sure the way they were filed was Mr. Sandlin and then Mrs. Sandlin. But Mrs. Sandlin predeceased him and hers is a muniment of title. I just want to make sure, do you want to go in docket order or do you want to do the muniment first?
Let's do the other one first.
Okay.
Cause number 28.
27. Oh, 28, all right. On this day, all right. My name is Colton Wade Mayo, and my personal knowledge of Eutha Gail Sandlin, aka Eutha G. Sandlin, is that she passed on February 1st, 2018 in Houston, Harris County, Texas, at the age of 70. Although more than 4 years have elapsed between the date of her death and the filing of the application of probate, applicants are not in default for failing to present the will for probate on or before the 4th anniversary of her death. To the best of my knowledge, they did not have knowledge that they needed to probate at that time. She was a resident of and domiciled with a fixed place of residence in Chambers County, Texas. I have a copy of the document dated October 14th of 1992, which purports to be her last will and testament. And to the best of my knowledge, it was never revoked. The decedent's devotees include Ronald Wayne Sandlin, her spouse, who is now deceased, Marcus Sandlin, her surviving son, who is an adult, her son Brian Sandlin, who is also an adult, and there are heirs who would inherit in the absence of these would be Ronald, her deceased husband, Marcus and Brian, her adult sons. She had no more children and did not adopt any children after the execution of the will. No marriage of hers was ever dissolved. The will does not name the state of Texas, an agency of the state, or a charitable organization as a devotee, and she did not receive Medicaid benefits on or after March 1st of 2005. According to my knowledge and the financial affairs of the estate, there is not an unpaid debt, and anything other than a debt secured by a lien on real estate. So there's no necessity for administration of this estate. We ask that you admit her will to probate as a muniment of title.
So done. Thank you, Counselor. You can go back to 27.
All right. It's always best with the ladies first, so now we'll go back to Mr. Ronnie. All right, my name is Colton Wade Mayo, and I have personal knowledge of the facts in this matter. Mr. Ronnie Wayne Sandlin, aka Ronald Wayne Sandlin, aka Ronald W. Sandlin, passed on October 28, 2024 in Pasadena, Harris County, Texas at the age of 78 years. So 4 years have not elapsed since the date of his death. He was a resident and had a domicile and fixed place of residence in Chambers County, Texas. I have a copy of a document dated October 14th, 1992, which purports to be his last will and testament, and to my knowledge, it was never revoked. A necessity does exist for the administration of his estate, and he had no children born to or adopted by him after he executed this will. No marriage of Ronnie's was ever dissolved. His will does not name the state of Texas, an agency of the state, or a charitable organization as a devotee. He did not receive Medicaid benefits on or after March 1st of 2005. And Eutha G. Sandlin is named as an independent executor in his will, but she predeceased him. So we have Marcus Sandlin and Brian Sandlin named as independent co-executors in their father's will. Neither of them is a convicted felon. Both are qualified and not disqualified by law from accepting letters, and both are entitled to receive those letters. So we ask that you please appoint Marcus Sandlin and Brian Sandlin as independent co-executors without bond of Mr. Ronnie Sandlin's estate.
Thank you, Counselor.
Thank you, sir.
Are you done?
I think that's it, unless
I
there's
think
a
it is
surprise.
too. All right. Take
Thank
care,
you.
Colton.
Have a good day.
All right, cause number 31, the state of my friend David Herbert Merle. Good morning, Megan.
Good morning.
You may proceed, Counselor.
Thank you, Judge. Megan, we're here today regarding your father, David Merle, and his will. And is it correct your dad passed away January 14th of 2026 in Chambers County? Is that right?
Yes,
And he resided in Chambers County at the time of his death.
yes,
And he left a last will and testament dated November 24th of 2014. Is that correct?
yes,
And to your knowledge, this will was never revoked or changed or anything. Is that right?
Mm.
And in the will, it actually first names your mother, Wandina, to serve as executor, but your mom is suffering from Parkinson's and dementia, and she's unable to serve. Is that right?
yes,
And you actually hold a power of attorney signed by her, and you're her agent under that power of attorney.
yes,
And then the will goes on to name you to serve as successor. In the event she can't serve, you serve as executor of the estate. Is that correct?
yes.
And you're willing and able to serve, and to your knowledge, you're not disqualified by law from serving as executor. Is that right?
Not this one.
Okay. And we prepared a proof of death and other facts that contains the rest of the information necessary for this matter. Have you read over that document? Is everything there true and correct?
Yes, sir.
That's all we have, Your Honor.
All right, admit the will of probate and authorize letters. Thank you, Counselor.
Thank you,
Megan,
Judge.
good to see you. Take care.
Thank you. You too.
All right, cause number 32, the state of Jacqueline Hanks Johnson. Good morning, Mr. Davidson.
Good morning, Your Honor.
And you may
Thank you.
proceed.
Thank you very much. Your Honor, Jacqueline Hanks Johnson, also known as Jacqueline H. Johnson, died on February 22nd, 2026 in Baytown, Harris County, Texas at the age of 86. This court has jurisdiction and venue in that she had a fixed place of residence in Chambers County at the time of her death. To the best of my knowledge, the document that's been filed with the court, which purports to be her last will and testament dated the 9th day of April, 1998, was never revoked, so far as I know. No state governmental agency or charitable organization is named in the will as a devisee. After the date of the will, there were no children born to or adopted by the decedent, and there was no marriage dissolved after the date the will was made. The will did name her husband to serve as independent executor. However, he predeceased her. Subsequent to that, the will named her daughter, Jennifer Susan Johnson, now known as Jennifer Susan Schubert, to serve as independent executor without bond. She is qualified and not disqualified to serve in that capacity. Your Honor, would ask that you admit the will to probate, that appraisers be waived.
So done. Thank you, Counselor.
Thank you, Your Honor. Have a great day.
You too.
Thank you, sir.